If the CRA has ever told you a transaction was legal on paper but still got reassessed under the General Anti-Avoidance Rule, there's one Supreme Court of Canada case that explains exactly why, and it still controls every GAAR case the CRA brings today. Hello, I am David Rotfleisch, a Canadian tax and business lawyer and a certified specialist in taxation. Welcome to the TaxPage Tax Channel. In 2005, the Supreme Court decided Canada Trustco Mortgage Co versus Canada. Canada Trustco bought trailers, leased them back, and claimed the tax deduction. The CRA said the whole point was the tax benefit and tried to deny it under GAAR. The court laid out 3 questions every GAAR case still asks. Did the transaction produce a tax benefit? Was it done mainly to get that benefit rather than for a real business reason? And did it go against the object, spirit, or purpose of the tax rule being used? That third question is almost always where these cases are won or lost, and it's the CRA, not the taxpayer, who has to prove it. To answer it, the court said you look at the words of the provision, the scheme of the whole act, and what Parliament actually intended together. That's still the exact test the CRA and the courts use, 20 years and several Supreme Court cases later, including recent decisions like Alta Energy and Dean's Knight. Parliament did update the rules in 2024 through Bill C-59. There's now a lower bar for what counts as an avoidance transaction, a new economic substance test, and a 25% penalty if GAAR applies. But none of that replaced the Canada Trustco test. It sits on top of it. The 3 questions the Supreme Court set out in 2005 are still exactly what the CRA has to prove today. If the CRA has raised GAAR against you, or you're planning a transaction and you're not sure where it lands, we can help you understand where you stand. Contact one of our tax lawyers at taxpage.com. We're here to help.